everybody, to Electronic Records Day 2022. Woo! Happy Electronic Records Day, everybody. Welcome to Access Denied, Not For You, the title of the presentation, of course, as our fine panel will go over copyright and confidentiality restrictions in born digital records in a variety of ways that I'm sure you're going to find very interesting. I am Josh Hager. I am the co-chair for the State Electronic Records Initiative Advocacy and Outreach Committee. My other co-chair, Catherine Giles, is also here. I'm also the Records Description Unit Supervisor at the State Archives of North Carolina. Very happy to have you aboard, and I'm very excited to moderate my second ERICS panel in a row. I did last year's as well. So let me go ahead and show you. Let's see. I want to welcome everybody and tell you that our next series webinar will be on November 16th at 2 p.m. Eastern, Digital Preservation Policies as Tools for Accountability, Compliance, and Clarity. I know probably a lot of you are interested in compliance if you're here at this webinar, so please keep that one in mind for November 16th. Also, be sure to check out our Resource Center on the COSA website. Our Tools and Resources group and series is always busy adding more to that wonderful place, as well as the recordings of past webinars through Siri on our YouTube page. I'd like to acknowledge the sponsor for Series 2022 webinars, Preservica, Active Digital Preservation. Our presenters today are Hannah Bergman, the Litigation Director and Chief Privacy Advisor from the National Archives and Records Administration, Sheilah Brous, the MDOT Records Officer and Director of the Office of Policy and Regulations with the Maryland Department of Transportation, and Lois, Hamill, University Archivist and Professor at Northern Kentucky University. And finally, just stay connected to us as we go throughout this panel through the various tools. We have the COSA website and Resource Center. Follow along with COSA on Twitter at State Archivist. Use it and subscribe to the COSA as well. And if you'd like to tweet this session, you can use the hashtag Day22. We'd love to see your live tweeting of this event as we go along. I will say that the actual talk recorded, and so please feel. But when we get to Q&A, we're going to stop recording. Just that if you have questions that might be a little sensitive with confidentiality and copyright that may happen, you don't have to worry about those being. All speakers speaking on behalf of them, they are not of their respective institutions. And that said, I will turn it over to Hannah. Hannah, you weren't here when we Becky can either assign you to move the slides yourself, or you can still tell me when you're. Sorry.
I can do whatever.
My sound came out. I apologize for. Okay. You want to tell me when you're ready? I'm going to mute and stop, buddy. Hannah Bergman.
All right. Hi, I'm Hannah Bergman. I'm the Litigation Director and Chief Privacy Officer for the National Archives. And I'm going to be talking a little bit about NARA's efforts to ensure confidentiality in federal records at the National Archives. So the next slide. The things that I wanted to go over today, just in a quick high-level thoughts on appraisal, accessioning, the differences between electronic records and in-person access, and how privacy and other restrictions can affect those things. And then talk a little bit about digitization. So the first thing really to keep in mind is, how do things get into the National Archives, right? And how does confidentiality come into play? And when we're thinking about what it is that the National Archives will be preserving for the life of the Republic. So we have NARA's appraisal policy. This has largely been unchanged for, I want to say like 15 years at this point. It's a high-level document that outlines what our collections policy is, right? I would expect, most institutions have very, very similar documents out there. And it does talk specifically about personal data records. Personal data records are one of the types of records that tend to come into the holdings more often. We have a whole appendix in the appraisal policy that's devoted to that. And in particular, I think if you think about the reasons why NARA decides that records might have permanent value, that we're going to preserve them for the life of the Republic, the policy outlines three reasons, really. Records that document the rights of citizens, records documenting the acts of federal officials, and then those that document the national experience. You can see that the first and the third one really are going to capture necessarily information, records that are going to contain a significant amount of personal privacy information, particularly in the records documenting the national experience section. And that's where we see genealogists really have a high level interest in the records. On the other hand, we also don't want to take into the holdings records that we're never going to be able to make available, right? One of the missions of the National Archives is that we are able to provide public access to the records. If records are so fraught with restrictions that are never going to expire, it's not necessarily going to be a great collection for accessioning. There are exceptions to that rule, but I think, there are oftentimes, particularly for law enforcement records, people will have just this idea that we can't sunset the restrictions, and because of the privacy interest, we're just never going to be able to open them. In those situations, we really have to have a hard conversation about whether or not that's appropriate for those records to be appraised as permanent, because the reason we keep them in the National Archives is so that the public can have access to them. And you may not get access right now at the moment of transfer, but the idea is that records that have restrictions on them, those restrictions should really sunset over time, because privacy interests in particular should diminish over time. So records about living people will require significant screening when they come to the National Archives. Obviously, that makes sense, right? We're not going to be releasing information that is protected under FOIA's Exemption 6. So the next slide. And this is just for those of you who may not be familiar with our transfer process. When records are created by federal agencies, and generally agencies will keep those records for between 15 and 30 years after creation, and at that time we'll get the transfer of records, whether it be electronic or in analog format. And when agencies transfer records to us, they have to indicate what the restrictions on access are. So which of the FOIA restrictions would apply to these records? What is it that's so sensitive about them? And we expect them to do that. They generally do it. Sometimes agencies are more or less familiar with the records, depending on the series. And so this is not always the most reliable information, but we do ask at time of transfer that agencies indicate the restrictions. When we review the records for access, we review at that point in time. So we may have a transfer that's 15 years old, and it has a privacy restriction on it, but in the passage of those 15 years, the privacy may have diminished such that we no longer need to protect anyone's privacy. But at least we get the information from the agency. So next slide. I wanted to just highlight a couple of examples of personal data series that have a lot of privacy information in them in the holdings of the National Archives. The personnel records are one of our, obviously most sensitive collections. Those are military and civilian personnel records. So these are people who either worked for the civil service or were in the military. The civil service records are not modern civil service records are not permanent, but older ones are. The Civilian Conservation Corps personnel records and the Works Project Administration records are also permanent and part of our holdings. Those are really of interest to researchers who are trying to look at migration patterns and how these big employment projects change the way families lived and moved around the United States. So those theories, I think, are valuable because of the personal data in them. And that can be one of the challenges about the personal data series, is that sometimes the way in which you protect privacy, is to remove the sensitive information. But in these data series, the sensitive information is what makes them interesting and valuable to researchers. So the research goals are often not able to be accomplished if we can't release the records. Next slide. So at the time records come to us, they're accessioned into the holdings, and we process them. And we process, and this is again a very high level overview. That we could talk about National Archives processing policies for a very long time. So this is just a broad brush. The devil's always in the details. But records are processed for access generally on a pass-fail basis, based on what the transfer paperwork says and the archival experience about those series. If a record passes, either the transfer of records, if it's a series of data files or if it's a bunch of boxes, if they pass, then that means they can go straight to the shelves and be available for researcher access without any additional review. If they fail, then more screening is required. And if it's an analog record, it might be eligible for our screen on demand process. And that's where an archivist trained on the special access and FOIA team may be able to look at the box of records and say, well, you know what, it's only really like these folders or these couple of pages that are problematic, and we can just do withdrawal split sheets for this small amount of information and serve the rest to the researcher. And that can be a good way to get the researcher access to the bulk of the information they need. Or it may fail even the screen on demand, and that means the researcher is going to need to submit a FOIA request for that, for those records. And that will trigger a line-by-line review of the records where we can do appropriate redactions to protect privacy as needed. Next slide. Electronic records obviously aren't eligible for the screen on demand process, but they do have that same sort of pass-fail initial cut. But we're going to have more. It's often harder to, I think, protect the privacy because of kind of the way in which data is manipulable, and you have to ensure that even if you just remove a category of information, are you really protecting the individual's privacy? Is it such that there's, even if you remove the name category or the social security number category, is the information in there still enough to identify the person? Because the population of people with those characteristics is very narrow. That's obviously always a challenge, particularly when there are large data sets. Because the data sets can be so large that we don't have necessarily the software or the computing power or the understanding of the records, the mathematical skills necessary to do these things quickly. It can take a long time to screen a large data set of records that's full of privacy information. And so I'm going to talk about a couple of examples of those. Next slide. So one of the things that we've accessioned in the past decade or so are files from the Social Security Administration called the Numerated records. That's the enumeration record. So every time you're enumerated, you get a Social Security number, all the records associated with that. The SS5 is the application for a Social Security number. When we got this transfer of records, the idea is you're supposed to either be dead or 110 years old at the time of the transfer, or when the cutoff was. And so that was December 31st, 2007. That meant we got 72 million records. And then as you can, so it's a very large data set, but there are only 40.8 million unique SSNs. And that's because every time someone had a transaction with the Social Security office, that record was appended to their person record, right? So if you got married and had a name change, then your application had two entries. One, when you were given the name you were given when you got your Social Security number. Two, when you had your name changed. Maybe you got divorced, then you had a third. Then you died, and that was a fourth. Maybe there were dependent benefits, etc. So that's how you end up with these very long chains of records. Not all Social Security numbers that appear in the application files are going to appear in the death records that we have. And this is because the way the NUMIDID death records are compiled and what Social Security transfers to us. State reported deaths are not state reported death. When a state reporting agency reports the death to Social Security, that information is not transferred to us, and it's not captured in the public use version of the death files. So since most deaths are reported by a state reporting agency, the death records are really very incomplete. So that means we have a lot of SSNs. We have some information about death, but not a ton. But the idea behind this transfer, behind the transfer language, is that it's everyone in this data set supposed to be dead, we think, or 110. At which point we assume that you're dead because 110 would be very old. All right, so the next slide. But it turns out that SSA didn't really understand the complexities of the data that they were transferring to us. And working with this data, we realized that there were a ton of potential privacy issues. One, there were different people living under the same SSA, and not just like I changed my name, but entirely different people, different birthdays. And then we estimated that about somewhere between 16 and 22,000 of the records we got had data with them. Obviously, we can't make these files available if we think that someone's been associated with the wrong SSN and it's really information about a living person that we'd be making available. And issue 2, we had 9,000 records that weren't in the death records, and the birth year was not 110 or greater, which is what should have been there, right? So we're going to have to figure out how to screen out those records, because that's 9,000 people that are potential of living. And then there are SSNs that appeared in death records, but for different people. So they were essentially just incomplete. Our archival team, said we can't review 22,000 SSN records for different people and figure out how these people are all linked together. We can't review 9,000 of these death records individually, right? We don't have the manpower to do that. If we were to do that, we're not going to be doing anything else for the next eternity. So they came up with an automated solution. They essentially pulled 75,000 records from the data. And that's a lot more than we would have pulled if we had done a line-by-line review. But it was a way in which we could pull out an extract and then confidently push forward a data set that we knew wasn't going to have any information about living individuals in it. And so if people come back to us and they're looking for information on a particular person, and they can submit a FOIA request, we can do a more refined look at that SS5 data with that name and date of birth and a social security number for a researcher, et cetera. But just as a data set, we're not able to push that out for proactive release without pulling out that large chunk of people. All right, so next slide. Another data set that I wanted to talk about is a really interesting data set to a lot of researchers, particularly academic researchers. And we've finally, this summer, we're able to enter into an agreement to make this data available to some researchers, and we hope it works out, and we hope that it is a good pilot program and we're able to expand it in the future. This is data about individuals who received reparations, which were paid in I believe the 1980s or early 90s by the Justice Department. And the reparations were because they were descendants of individuals who were interned in the Japanese internment camps during World War II. So this data set is particularly interesting to the academic researchers because it allows people to kind of, again, to see migration patterns and economic patterns associated with the vast movement of people over time. And it's, I think, one of the most frequently requested data sets that we have that's closed, that it seems like all academic researchers want to look at for one reason or another. And we just have not been, we weren't in a position that we were able to provide that data to the researchers because of the privacy restrictions. Now, sometimes you can go ahead and provide access to closed electronic records or closed archival records if you enter into, an agreement with our academic researcher because they've met like this whole list of qualifications. They've got their internal review board of their institution to sign off on it, and they promise that they're not going to disclose any of their personal information. They're going to de-identify everything in their study. But we were not comfortable with doing that with this data set, given kind of the complexity of the data and the fact that it was electronic. And so we had just not been able to make it available. We were this year able to enter into an agreement with the Census Bureau for use of their RDCs. And I don't know if folks are familiar with the RDC program, but essentially the Census Bureau has for a long time operated this network of data centers where agencies can host data sets for academic researchers. So you see this, so if you're an academic researcher at a university, you can go access the raw census data that is identifiable down to individuals in these data centers. You can access IRS data as well. You can compile those, and then I think there's some housing data there, et cetera. So Census has long operated these to fulfill this need for academic research, social science research that requires information about individuals. And they vet everyone through through a vetting process. You have to be sworn that you're never going to reveal this information, and then you have to access it in a very limited environment. We were able to enter into agreement with Census and the researcher. This was a well-funded researcher, and the researcher was able to pay the cost to Census of transferring the data set to the Census, getting it loaded into the data center, de-identifying it, and doing all of the Census magic to it that makes it safe for the researcher to use. And so Census is handling all the restrictions on access, et cetera. We've explained to them what our concerns are. They're implementing those. And the researchers are going to be doing their research over the next year. So over the summer, the data got loaded into the RDC, and folks are going to have access to it. So it will be interesting to see if this really works out as a long-term model. I can tell you that it's very expensive to load data like this. It was a project that was well over $100,000. And like I said, the researchers had grant money that they were able to fund that project. And so, not everyone is going to be able to make that significant cost outlay, but our hope is that the more we do it, the more the cost would come down, and that for researchers that are well funded, this would be a way in which they can get access to the data. All right, so next slide. All right, so moving on from those examples, I just wanted to talk a little bit about in-person access to analog records, and then about digitization. If you've ever been to the National Archives, you may realize that NARA has for decades served in our research room analog records that have a significant amount of personal data in them about living individuals. This is particularly true for a lot of the Vietnam era military records, because the military would just add your social security number anytime they talked about you. So it'd be Hannah Bergman, SSN, went to the sick bay today on her ship, right? Like just a gratuitous social security number use throughout their records. And they've always been open and available. I believe they even came to us as open and available. They're not name retrievable, right? So you can't just go and search by someone's name in these records. But obviously, when we serve them, people can digitize them on their own. Researchers can digitize them. And so that means that they can become searchable and name retrievable, even if we're not making them name retrievable. We have continued to live with that access decision, and we provide on-site access to those records. And we don't believe that they're good candidates for digitization. We're not going to be scanning them and putting them on our website tomorrow, but someone else could, and that is kind of the risk that we live with, and just the reality of the fact that decisions were made about release of these records at a point in time where privacy was treated a little bit differently, and the risk to individuals were different, and we can't close the collection now because there's still a significant benefit for public access to them. So the next slide. So to kind of figure out a way around handling these quirks, we have, when we have digitization projects, we have created a privacy checklist for digitization so that we can identify when a series has these random SSNs, or maybe SSNs in a particular, like it's a form and there are SSNs in particular structured data fields, etc. So these are the 3 questions that we ask. It's a very high level, very basic checklist. Are the records 75 years or older and pertain to adults? If yes, great, please scan them. If no, then are any of the following data types SSNs of living people, fingerprints, financial information, medical information, sexual history information, criminal history information? If yes, whoa, that's a moment we're going to need to talk about. Maybe not the best candidates for digitization. If no, then you can proceed, and then we ask, are 2 or more of the following categories of PII present? Date of birth, place of birth, mother's maiden name. If no, then go ahead. So I think this is kind of designed to just provide staff in our various locations with a quick way to assess whether or not something should be at the top of their list, or for digitization, or if it's something that they should wait a little bit longer on. And so that's how we've been handling privacy in the National Archives and confidentiality. And I'm happy to take questions and talk more about it later. But we can turn it over for the next presentation.
Thank you so much, Hannah. And next, I'd like to welcome Sheilah from the Maryland Department of Transportation. Sheilah Brous, please go ahead, and I'll continue driving.
Hi, everyone. I am Sheilah Brous, as I said, from the Maryland Department of Transportation. I am the director of the Office of Policy and Regulations. So both Records Management and Public Information Act requests fall under me. And you can go ahead to the next slide, Josh. We are a little different, and our perspective is going to be different from a lot of you. And I think we're not coming from the archivist point of view necessarily. We are the agency, and we are the end users. We're the record creators. We're also different from almost every department of transportation across the country. We are an umbrella organization, and this slide does a really good job to show that. We have the aviation under us, the port, the transit, the motor vehicle administration, and the highways. We also have a lot of our funding goes to WMATA. If you've taken the metro in DC, a lot of our funding goes there. And then the Maryland Transportation Authority, all the toll facilities within the state. So really big department, spread all the way across the state, a lot of different types of records that we're creating. And an old department with a lot of legacy systems, different types of records, a lot of paper, and certainly, we've certainly gone through a lot of electronic records, and COVID kicked a lot of our systems into electronic records, and struggling what to do with a lot of that. Next slide. So for us in thinking about this topic and with the limited time that we have, I could talk all day just on records management and Public Information Act requests, which is like the FOIA for everyone else, but for us under the state, PIAs are what we typically talk about. There's really 4 pieces. It's how we in the state of Maryland deal with records management, the public access process, privacy and confidentiality when we're handling and releasing records, but also on the system side and data privacy and protection and how we do that. Next slide. So we take it very seriously. I mean, under our current governor, there's several things that we do, but also the leadership in Maryland. And we are very committed and mindful of the fact that records management and public access go hand in hand, and that every single person who works for our department is creating records. And I am encouraged by the fact that as we have a lot of baby boomers leaving and a lot of new employees coming in, we do get phone calls from people that say, I just started this job and there are boxes piled to the ceiling. What do I do with these? Or someone who's leaving and says, I've been in this job for 40 years and I've created all these records. What do I do with these? I don't know what they used to do with them in the past, but they are actually calling us now to figure out what to do with them. And I think that's a really good step, that we are starting to make them think about the records that they're creating and do they have value and what we do with them. Next slide. So we have more than 10,000 active employees across the state, as well as contractors, consultants, temporary employees. And we create the typical records that an employer of our size would create, from HR records and accounting and payroll, for construction and engineering activities. We also have driver and vehicle records that have all kinds of PII and digital photographs. We have medical records and psychological information for people that maybe should be driving or shouldn't be driving, and paratransit for mobility records for people who maybe need some help on the transit side. All of the email and the chats and the recorded meetings now and training sessions. MDOT, through our procurements, because of the amount of procurement that we do and the contracts that we do, MDOT actually has the minority business enterprise and deals with the disadvantaged business enterprise applications with all the finance and the trade secret and the commercial information. All goes through MDOT. So the types of records that we have across the state runs the gamut, and we have to deal with managing those and then any requests for any of those records that come in. Next slide. So Maryland's Public Information Act has been around for a while. Big changes were made to it back in 2015 that really required MDOT to sort of centralize that within my office and standardize how we deal with it as a department. And we made a lot of changes as a department. And the intent of the Maryland law is to provide broad access for the public, and do it in a least expensive way that would allow the public to have access, but also to protect the privacy, the confidentiality, and all of those other things that we do worry about. What are the things that we are also obligated to protect in those records? We have critical infrastructure, we have homeland security and public safety issues, and we have ongoing investigations and all sorts of active procurement. So what is our responsibility to provide sunlight to government operations and records, but what is our responsibility to protect those records as well? And sort of doing that dance and that balance and how we do that. Next slide. So really the law aims to look at the legal privileges and personal privacy, financial privacy, medical, commercial protections, the integrity of the types of investigations that we do, and public safety, and try to balance all of that. Next slide. the law that we have, and I know, we talked about it in preparing for these presentations today, and it does give us what's called a 10-day notice. The law states that any request for a record falls under the PIA. So we deal with millions of records requests in any given year. Anyone who requests their driving record, or vehicle record, or their Easy Pass account record, or anything like that, that does fall under the PIA. But in the normal course of doing business, they get those and don't legally have to file a PIA. If we fail to give it to them, then they can follow all the remedies and everything else. But when someone's requesting my driving record or some other type of record, it falls under this process. And it means that we have to respond as quickly as we can. If we're unable to respond within 10 working days, there are certain things we have to do. We must get a letter to them that says the amount of time we're going to need and the reason for the delay. And if there's an estimated fee, what we think we're going to charge them after the amount of time they get for free. And if we anticipate that we're going to need to deny or redact anything and what we think that is. And if we don't think we have records, and if you can imagine all of those types of records and where we physically think they might be and who might have them, and to be able to do all of that within those 10 days can be a really big lift, just to be able to do that. Next slide. Now, like I said, not all records are necessarily available. If someone wants video footage within a tunnel for Homeland Security reasons, we may not give them to them. We're certainly not going to give video to someone that may show them what the weaknesses in a tunnel is. If someone wanted to be able to post that on YouTube and then someone tries to blow up a tunnel because of that, there may be various reasons as to why we don't give certain things. But then there are other things that we may need to release or we are perfectly capable of releasing. So there's three general categories. One is something that another law or regulation requires us to deny. We are just flat out required to deny that for another reason. There are some things where we're required to partially deny or redact something. And then there's another category where we have discretion in order to be able to do that. It may be pre-decisional or a work product or attorney-client privilege or something where there is some discretion that we can choose to do it or not do it, or it may be waived. Next slide. So one example of something that we may be flat out required would be an ongoing procurement. If we have an open procurement and someone requests records for something that is out on the street and it's being competed for, if we were to release any part of that, it would affect the outcome of that ongoing procurement. Once that procurement is awarded, then we're able to release some of the records having to do with that. But if it's something that's ongoing, we would not be able to do that. It would be denied. Medical records, critical infrastructure, personnel records, there are just certain things that certain laws and regulations require us to deny them flat out. Next slide. Some of the things that would require us specific classes of information within records that could lead to redactions or denials. Information that we would require to protect would be PII or medical information, digital photographs. Now, it's interesting to listen from the federal level because when our state law, for us, sociological information, we can't redact a person's name. We're required to provide the person's name, but we cannot release their home address or their personal phone number or their personal email address. But if we had to release a bunch of records and their name was on those records, we cannot redact their name. But any other sociological or other information on there, we would have to release the record with their name on it. And then you can see the other types of information that we could or would need to redact. Next slide. And then these are the sorts of things that, that there would be discretion as to whether or not we may have the ability or could choose to. Next slide. These I'm not going to read off for everyone, but I did provide some very specific examples with the Maryland state statute citations for you if anyone had interest in that. So there are a couple of examples. Next. And a few others. So this would be the example for driving records. Next slide. Now, when we go through and actually produce a Public Information Act request, the way that we go through and actually produce them, we do it in a very secure environment. It's very limited as to who has access to it. We're constantly changing passwords. Our IT people ensure that it's in a secure environment, that our cybersecurity people ensure it's safe and it's not getting hacked into. We run audits to make sure that the people that are using the site are using it for appropriate purposes and only for business reason. When we are doing e-discovery searches on people's emails to make sure that they're doing what they're doing, we make sure that every PIA request has a unique number, and we verify that that number is associated to the searches in the emails and that they're using it for appropriate reasons, so that somebody's not just going in there and searching somebody else's email for a reason that they should not be doing it. When we have people going in and transferring files for others to be looking at it to review or approve what people will be using, we put them on secure servers, again, so only the people who should have access to that information actually have access to that information. When it's possible, we will convert things that we have to produce, files we have to produce, to flatten files and not use the native files. But if the requester is asking for the native file, the state law requires that we give them the native file. But we try to go in and do it a way that, to every extent possible, in any way that we can provide privacy and confidentiality of information, we try to do that. Next slide. And again, this is talking about the same. We try to restrict the personnel who have access when we're doing protocols for file transfer, and again, the native records that we're working within. We try very hard to make sure that we do whatever we can do to restrict the people that are looking at them and restrict the information to only what the people asked for and only what they actually need. Next slide. And this is really important. Our current governor issued an executive order in 2021 and created at the state level a chief data officer and a chief privacy officer at both the state level and at the agency levels. And they meet regularly. And then at MDOT, we have a data officer and a privacy officer. And our state legislature back in, I want to say 2018, created a records officer through state legislation for records management. And I serve as the records officer for MDOT. And the three of us meet to look at what we're doing from a systems point of view, what we're doing from a privacy point of view, and what we're doing from a records management point of view. Next slide. And this really comes from the systems point of view to look at what we're doing for PII information, for all sorts of different information system-wide, because our system looks at information and where all of these various things are and what we are doing with the type of data and information that we have in our emails. What are we doing with this information? Is it scanning it? Are we protecting it across the board? And it's looking at the threat sophistication and what our security capabilities are. And you'll notice at the very left where it talks about what it protects and where our tool-based abilities were, that's where we started. And now we are up near the dynamic defense and we are working towards being resilient. And next slide. And our data security officer really talks about the CIA of information, the confidentiality, the integrity, and availability to make sure that we protect the information and it is confidential and only the people who need to use it are the people allowed to use it at many different levels, that the information is reliable and accurate, and that our systems are able to be protected, not just the records that we're providing, but the records where we're storing them and the systems where we're keeping that information housed, and that it's available to the people who need it when they need it, but only available to those people. Next slide. And again, talking about the security of PII information, and the various credit card information and the other information that we have. And even just talking about email, the fact that MDOT went to fully encrypted email to be able to search for PII, it automatically does that for everything coming into our system and going out of our system. And if there's something within our system that I am not sure if the email is encrypted or not, there is a way that I can manually encrypt that email, sending it just internally, and ensure that that information within that email is encrypted. So we try very hard to ensure that everything that we are doing within the system, we are protecting the privacy and confidentiality of every record that we have to the extent that we possibly can. And Josh, I noticed someone did put something up to ask about the citations. Are these slides going to be available after today's webinar, that if someone wants to get some information on it, they can?
Yes, the slide deck will be posted to the COSA website.
Okay, great. I think that's it for mine. Yep.
Thank you so much, Sheilah. And finally, we turn it over to Lois Hamill for Ernest Gets Tangled Up. Lois, the floor is yours.
Thank you, Josh. This panel so far has discussed the intersection between records we want to provide access to for our researchers and the law. Providing access, as we've heard, can be a delicate balance of conflicting interests. Because of the ease with which electronic records can be duplicated, copied, and transmitted, they are more difficult to control than analog records. Once they become public, they are difficult to delete or recapture. I've been an archivist for over 20 years, and during most of this time, I have managed photograph collections. One collection was comprised of photos taken mostly by contract photographers, and the other created by a university photographer. And for me, copyright is the most common question I have addressed when considering a researcher's use of photographs or other materials. The most helpful advice I can give you is that copyright is about risk assessment. Information is readily available about copyright and in particular fair use. And there are a number of good tools that are available to conduct a fair use risk assessment. And I would say that what I'm about to present is a case study of copyright and risk assessment. Next slide. Okay.
So I think, Lois, you had the power. Becky, if you want to give it back to me, I am going to navigate.
okay.
So you're good, Lois. You're good. Next slide. Thank you.
Yes, okay, that's where we are. Thank you. So typical of many special collections departments, the archives at Northern Kentucky University's Steele Library collects records that document our region's history, including business history. A while ago, I was trying to update the collection to bring it forward into the 20th century, and we identified a local family business that had evolved into a regional powerhouse, Trout Dairy. The Lewis Trout family dairy started in Newport, Kentucky in 1920, and you can here see the plant exterior. Next slide, please. This is the bottle washing machine and some of the employees. Next slide. This is the filling machine, which was used to put the milk into the bottles. And next, this is the accumulating table where the filled bottles accumulate, and it bottled 500 gallons in 75 minutes. Next. And this is the filling room, which produced 1,000 gallons of milk per day. Next. So about 1968, the dairy acquired 2 ice cream trucks and 1.5 routes for those ice cream trucks, and grew to a regional powerhouse. About 1998, they were bought out by Suiza Foods, who in turn bought rival Dean Foods about 2003, because Dean Foods had greater name recognition than Trout. And you can find Dean products in the dairy case, and sometimes I've still seen the Trout name, although it's been a while since I've checked. Production in Newport, Kentucky stopped in 2011. Next slide, please. In 2012, Special Collections acquired approximately 200 pieces of a variety of magnetic media formats dating from 1985 through 2003, and they consisted primarily of television commercials that advertised a variety of the products from the dairy. Funding was given to digitize what resulted in approximately 100 30-second television spot ads, which seems like it's a sufficient amount of ads for a class to work with for an assignment. I think the ads have potential to teach how Trout marketed, and that they would be worthwhile to study to answer the question of what did they do to bring about such growth. Are there lessons that are still applicable today? My initial target for using the ads would be the university marketing or business classes. Next slide. So while we were working with the collection, we learned that Trout had hired Cardin and Cherry, an ad agency in Nashville, Tennessee, in 1983, and they remained with the agency until 1994. The agency produced advertising for over 100 dairies nationally. They hired actor Jim Varney, who created the well-known character Ernest. Ernest appeared exclusively in Trout commercials in the greater Cincinnati market. He advertised for other dairies in different markets, but for Cincinnati, he only worked for Trout. Varney was so effective as Ernest that older local residents still remember his ads fondly. And this is a photo of Jim Varney here with Lois Trout Jr. and some other family members. You can see the Trout logo on the back of the truck in the background. Next, please. Varney transitioned Ernest from advertising commercials to a successful movie career, appearing in numerous Ernest movies. He also played Jed Clampett in the Beverly Hillbillies film version, and he voiced Slinky Dog in the first 2 Toy Story movies. He died in 2000. Next slide. Our intellectual property librarian reviewed the copyright status of the commercials for us, particularly the Cardin and Cherry ads. And the agency registered their copyright for their ads, which restricts how we can use and deliver them. Also, unfortunately, they have gone out of business. Otherwise, we would look at maybe making a written agreement with them of some sort on ways that we might be able to use it for educational purposes, but that is not an option either. Many of the ads date to about 1985, and if you look at the Cornell copyright chart, that indicates that they won't go into the public domain for 95 years. Which is more than 50 years away from now. So we're trying to figure out, as others have said, what kind of access can we provide at this point. Next slide, please. So the copyright issue brings us to the delivery dilemma. We can show the ads to people, but they can't download or copy them. So this prevents us from delivering the ads using our digital repository because it's publicly available and there are no password protection to it. And so we've been trying to determine what kind of a delivery method that we can use for some time. Initially, I thought that researchers would have to physically come into the archives research room to watch the ads using a standalone computer so that we could limit what they could do with it. Next slide. About a year ago, I tried again and I spoke with IT, NKU currently uses Canvas as its course management software, and this sounds like a perfect solution. Canvas automatically blocks downloads and copying, and the idea is to develop a Canvas course, which would also require a password to get in or a course enrollment in order to have access to the course. Our next step is to develop a test course with a few of the ads to determine whether it works as advertised. Essentially, we would be creating, next slide. Essentially, we would be creating a digital repository inside the Canvas course if it works as we hope it does. It would be password protected though, and it would allow just viewing and no duplication of any sort. The community researchers, we think, would still have to come in physically to see the ads. They would come into the research room, and we would use a public logon credential, which staff personnel would enter in for the researchers in order to provide access to the Canvas course for them. So this is where we have reached with our efforts to try to respect copyright, but also provide as much access as we can. And we hope that we have found the solution in this balancing act. And I just want to clarify that at the time the collection came into us approximately 12 years ago, 10 years ago, NKU had Blackboard as its course management system, and it didn't have the capability that Canvas does to limit downloading and reproduction and things like that. So yes, thank you.
Thank you so much, Lois, and thank you to all the panelists for an amazing presentation. So we have questions and comments. We've pretty much reached 3 o'clock. So if you have to leave, I completely understand.